The Constitution of the United States of America was written over 200 years ago. In these words, the freedoms and the rights of American citizens are spelled out, preserved, and protected. The powers of the central federal government are divided, checked, and balanced into three divisions: the legislative or lawmaking branch, which includes Congress, the executive, which includes the President, and the judiciary. Only the judicial branch has the authority to determine whether a law passed by Congress or a presidential action is constitutional. The highest court of the judicial branch is the Supreme Court. In civil and criminal cases, its decisions are final. We present now the history and functions of the Supreme Court. The first charter of government for the United States was proposed in 1777, a year after the Declaration of Independence. It was adopted by all 13 states by March of 1781. This charter, called the Articles of Confederation, was very weak. It did not provide for a federal court system. The Articles assumed that the state courts would retain jurisdiction over all civil and criminal matters. Within months of its inception, it was clear that this new system was simply not working. When the Constitution was written in Philadelphia in 1787, the delegates to the Constitutional Convention, George Washington, James Madison, John Marshall, and others, did not spend much time on the federal judiciary. They agreed to provide for a Supreme Court, but did not say how many members the court should have. They left it up to Congress to decide this question and to decide whether there would be any federal courts below the Supreme Court. The delegates also decided that the President would appoint all federal judges, but that the Senate would have to confirm these appointments. The final version of the delegates' deliberations can be seen in Article 3 of the Constitution. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior. Put simply, these judges would serve for life unless removed from office for serious offenses. The Judiciary Act of 1789, signed into law by President George Washington, was one of the most important federal statutes ever adopted under the Constitution. It established the structure and authority of the federal courts according to the Constitution. The Judiciary Act created a 6-member Supreme Court with a Chief Justice and 5 associates. As our nation grew, more judges were added to the court. The numbers changed, but since 1869, the court has 1 Chief Justice and 8 associate justices. The Supreme Court was given the authority to hear and decide appeals from lower federal courts and to hear and decide appeals from decisions of state courts on matters affecting the Constitution or federal laws. President Washington appointed the first justices of the Supreme Court. Confirmation by the Senate was swift. The Supreme Court convened for the first time in New York City, the first capital of the United States, on February 4, 1790. This session was one of ceremony rather than serious business. The court began to hear and decide cases only after it had moved to the new capital at Philadelphia at the end of 1790. John Jay of New York became the first Chief Justice. He had authored New York State's Constitution and served as its first Chief Justice as well. A firm advocate of separation of powers, Jay left his mark on court history with his decision in Chisholm v. Georgia in 1793. It was the first major decision of the Supreme Court. It ruled that a citizen of one state can legally sue another state. This was in effect until the 11th Amendment to the Constitution was ratified in 1798, outlawing such a practice. The 11th Amendment limited the powers of the federal courts, as well as being the first to overturn a Supreme Court decision. John Jay resigned from the High Court in 1795 to become governor of New York. In 1801, the Supreme Court convened for the first time in the nation's permanent new capital in Washington, D.C. On February 4th of that year, John Marshall was sworn in as the nation's 4th Chief Justice. He would hold that position for 35 years. During his tenure, Marshall changed forever the nature of the Supreme Court. Known as the master builder of the modern Supreme Court, His judicial opinions are at the very foundation of American constitutional law. In 1803, for the first time, the court declared an act of Congress unconstitutional in Marbury versus Madison. William Marbury had been promised an important government position by outgoing President John Adams. The new president, Thomas Jefferson, refused to honor that promise. Marbury decided to take his case to the Supreme Court. Marbury believed he was entitled to do this by the Judiciary Act of 1789. Chief Justice Marshall stated that although Marbury should be given his position, the court had no power to rule on the matter. Marshall asserted that according to the Constitution, a case such as this had to be heard by a lower court first, even though the Judiciary Act disagreed. Marshall argued that the Judiciary Act violated the Constitution and could not stand as written. This ability to examine acts of Congress and determine whether or not they follow the rules laid down by the Constitution is called judicial review. Today, judicial review is looked upon as a historic right of the Supreme Court, part of their responsibility to determine whether a law passed by Congress is constitutional. John Marshall believed the Constitution gave the federal government greater authority than the states had, and his court promoted such a belief. The Marshall Court established federal supremacy and promoted supremacy of the court over state judiciaries. During 35 years as Chief Justice, he had personally written more than half of the court's decisions and had shaped the Supreme Court into what it is today. Chief Justice Marshall died on July 6, 1835. To mark his passing, the bell in Philadelphia was tolled, and it cracked. It was never rung again. It is now famous as the Liberty Bell. To succeed John Marshall as Chief Justice, President Andrew Jackson appointed his Attorney General Roger B. Taney. Though Taney was an outstanding Chief Justice, history will always remember him for the 1857 case Dred Scott versus Sandford. It is widely considered today one of the most disastrous decisions ever handed down by the Supreme Court. Dred Scott was a Missouri slave who lived with his master for a brief period in the free state of Illinois and the Wisconsin Territory, where slavery was illegal. Upon returning home, Scott sued for his freedom on the grounds that he had become free when he left the slave state of Missouri and entered the free state of Illinois. To Taney, the Dred Scott case seemed to be the perfect occasion for the court to resolve the national controversy over slavery and the Constitution once and for all. Taney and the other justices made two fateful declarations. First, the court said Dred Scott was considered property. Therefore, he was not an American citizen and not entitled to sue in the courts. Second, the court claimed that the Missouri Compromise was unconstitutional and that slavery could not be prohibited in the territories. Taney's ruling meant that only a constitutional amendment could outlaw the expansion of slavery. At the time, this was considered politically impossible. The Dred Scott decision infuriated the nation's anti-slavery forces and was a factor leading to the Civil War. Ironically, 2 months after the court's decision, Dred Scott was given his freedom by a new owner. After the Civil War, some southern states were determined to limit the rights of newly freed slaves. Their answer was segregation laws, which allowed for separate but equal facilities for whites and blacks. Louisiana had passed a law requiring railroads carrying passengers in the state or through the state to provide separate cars for whites and blacks. The railroads opposed this law because it was very complicated and too expensive for them to comply. The railroad set up a test case in which a black man, Homer Plessy, tried to ride in a whites-only car. He was arrested and convicted. The railroads financed his appeal to the Supreme Court. It was now under the leadership of Chief Justice Melville Fuller. In May of 1896, the court ruled that separate but equal facilities did not violate the Constitution. The court ruling condemned generations of African Americans to suffer second-class citizenship in the land in which they were born. Separate but equal remained the law of the land for over 50 years. During the late 1800s and early 1900s, the nation grew from being a country of farms to a country of factories. Business boomed and giant corporations accumulated great wealth. During this period, the Supreme Court, as well as the Congress, in case after case, seemed to consistently side with big business rather than that of the ordinary worker. Even when Congress outlawed the practice of child labor, the court struck down the laws, claiming that businesses have a constitutional right to make whatever kind of arrangement they like with their employees. Boys and girls as young as 10 years old were working up to 12 hours a day at jobs that were considered unhealthy and even dangerous. It was during this period of big business that two justices gained notoriety from the Supreme Court, not by agreeing with the majority decisions, but by disagreeing. Oliver Wendell Holmes, Jr. and Louis Brandeis wrote many great dissenting opinions on the bench. They believed in protecting the rights of the individual and also to protect the government's power to pass laws to solve social and economic problems. Later on, in future Supreme Courts, many of the dissenting opinions written by Holmes and Brandeis were adopted. Former President William Howard Taft became Chief Justice in 1921 after the unexpected death of Chief Justice Edward White in May. Ironically, Taft was succeeding the man whom he himself had appointed Chief Justice 11 years earlier. In fact, Taft had appointed most of the members that were currently sitting on the bench. William Howard Taft is the only president ever appointed to the Supreme Court. Taft's masterstroke as Chief Justice was the 1925 Judiciary Act, often called the Judge's Bill because the justices wrote it. In response to Taft's intense lobbying, Congress agreed to shift the court's primary focus from mandatory to discretionary review. The net effect of this was to give the justices enormous control over which cases they would choose to hear. In 1929, at the request of Taft, Congress appropriated the sum of $9,740,000 to house the court permanently in what Taft called a building of dignity and importance. The court held its first session in the new building October 7, 1935. It is the home of the Supreme Court today. Chief Justice Taft retired from the court in February 1930 and died a month later